Welcome to my kitchen table lectures. Here's my recipe for your success. Welcome to the second lecture on European institutions. Now we've discussed in length really the source of the European institutions and how they were formed. We've started to talk about the application, that is the role of the institutions, what role they play. And we've started to talk about the effect on member states, the power that they have. So, for example, the European Parliament, the power that has on legislation, that it creates legislation that is then binding on member states. And as far as we're concerned, that's mainly because we of the Act, the European Communities Act of 1972. But we will need to talk a little bit more detail about the Court of Justice of the European Union. And this is one of the final institutions that we're going to talk about in our lectures. So what is the role of the Court of Justice of the European Union, or formerly the European Court of Justice? And you'll see it applied in textbooks or written about in textbooks using both names, but don't be confused, it is the same one. So the main role of this court is that it actually applies the law and tries cases, and it interprets EU law. Okay, so it applies and it actually interprets the law. Okay, it's based in Luxembourg. And if we look at who can actually bring a case, we have two main areas here. We have the Commission that feel that a member state could possibly be in breach in one of the regulations or directives issued from Europe, or a treaty obligation, and will warn that member state. And if the member state then doesn't comply, then they possibly can take that case to the Court of Justice of the European Union. Moving on from that, it also has an incredibly important role as far as a supervisory role, sometimes it's referred to. And this is where the member states can actually seek interpretation of a certain area of European law. Remember, we now have 28 members. We've got to make sure that the law is consistent and consistently applied. So unlike where member states could interpret their own law themselves, we have to have an interpretation from, if there's one existing, from the Court of Justice of the European Union. Otherwise, we have no consistency as far as the application of law is concerned. And remember, it is based on a very important principle, which is the doctrine of the rule of law. And as we know, we need everything to apply equally, and that's why that's very important. So what approach does the court use? Well, as far as its interpretation is concerned, it uses the purposive or teleological viewpoint. Therefore, it looks at the intention of and why a piece of European legislation was created. It doesn't make up its own decisions. That's what it's using as a basis for its interpretation. It doesn't create law itself. Remember, it's the judicial arm of the European institutions. Okay. It's unlike our courts. So in judicial precedent in the UK, we'll see when we study judicial precedent again that courts are bound by higher courts in the hierarchy, or if they're one of the courts in the hierarchy, so for example the Supreme Court or the Appeal Court, then those courts are bound by themselves. So the Court of Justice of the European Union is really quite unique in that it isn't bound by its past precedents. Okay then? And of course, member states, we are bound by the decisions of the Court of Justice of the European Union. Unlike the Court of Human Rights, where we have to take those decisions into consideration, here we are absolutely, definitely bound. And that is because of enacting, as far as we are concerned, us as a member state, the European Communities Act of 1972. And that is why we are bound to its decisions. Okay, so we're going to have one little example here of a case. So the Retachographs EC Commission versus UK 1979. And this is when the European Court of Justice upheld really a failure of the UK to implement a European regulation which aimed to prevent dangerous lorry drivers carrying dangerous goods and so forth, large lorries, from speeding, where they would have to actually fit a tachograph which would control really and record really what speeding they did. So it's to make everything a lot safer. So this is one example of a successful court and the Commission actually taking the UK to court. Okay, the Court of Justice of the European Union, one of the most important roles it has, apart from trying cases, is its supervisory role of the for member states. Therefore, under Article 267, Treaty on the Functioning of the European Union, it can be referred to by any court of appeal if clarification on European Union or EC law is needed. There tend to be around approximately 20 cases that are referred to in a year. But the question has always been when to apply. Now, the main case you need to look at for this is Bulmer versus Bollinger with Lord Denning. And Lord Denning set down guidelines of when he felt that courts should apply, and indeed when they shouldn't apply for interpretation. And really, he said the problem is that the delay involved, which could be around 9 months, would mean then that justice wouldn't be served, and also it was a very costly business. So his argument was, unless it was a point that was really difficult to understand and important, then you shouldn't seek clarification. Now, other arguments have been made, and he has been criticised in that it's believed that if clarification was sought a lot sooner rather than later, you wouldn't have the expense of cases being dragged up through the appeal system. But this was one of the first cases that set guidelines, so this is a really good one to learn. So if we go on, and we said we talked about before, but we have to know the source of law as far as European institutions is concerned, the application and the effect on member states and reforms and so forth. Let's go to a case that which gives an example of the effect. So a good example in use of Article 267 is Marshall versus Southampton and South West Hampshire Area Health Authority, 1986. So a good example to show the effect of the Court of Justice of the European Union, or as then the European Court of Justice, was shown in the case of Marshall versus Southampton, 1986, and that was using Article 267. Now this concerned the issue of retirement age, and Marshall actually challenged the retirement age. She didn't feel that she wanted to retire. She was asked to retire because she was a woman at a younger age, whereupon men could stay in employment until they were 65. She challenged this and said that this conflicted with European law. Now, the court referred this to the European Court of Justice, and it was decided that indeed it did conflict with a council directive, and indeed did conflict with EC law. Now, of course, the UK had to then comply, because we have to comply with EU law, and the UK in response changed its law to actually conform then with European law. So that was a really important case. Okay, we also know, and we will remember from our lectures in class, that we have the Court of the First Instance, who is now referred to as the General Court, that have taken quite a few cases and the workload away from just the Court of Justice of the European Union, because it was getting too difficult and too cumbersome for them. Okay. So remember, you need to actually go back, look at your notes and find cases and an example to support each of these following things: the source, the application of the law, the effect it has on member states, and indeed what we're really concerned with is the effect on our legal system, and any reforms as well. So we've European institutions have changed their name, and the institutions, for example, the European Court of Justice, has actually changed our law and prompted us to change our UK law. And that can be showed in Marshall versus Southampton. Okay then. We're going to go on next to one of the challenges as far as an effect is concerned, we're very concerned with, is the impact on our sovereignty of Parliament.